What is prior art? Prior art is any evidence that an invention is already known or publicly available before a patent application filing date, including patents, publications, and public, commercial use. It acts as the benchmark for determining if an invention is truly novel and non-obvious, often rendering a new patent application invalid if the invention already existed. Key aspects of prior art. Public availability. The core requirement is that the information was accessible to the public, regardless of language, location, or format, before the filing date. Types of prior art includes patents, scientific literature, websites, posters, oral presentations, and existing commercial products. Scope. It is not limited to physical products, it can be an idea, design, or formula described in any medium. Timeframe. Any disclosure before the effective filing date of the patent application counts. Compensation. Claiming compensation or asserting rights based on the concept of prior art generally involves demonstrating that an invention, technology, or creative work was publicly known or available before a patent application was filed, thereby limiting or invalidating a competitor's patent rights. While prior art is commonly used to invalidate patents, it can also be used defensively to secure compensation for licensing or to invalidate substandard patents in legal disputes. Understanding prior art as a tool for action. Definition. Prior art is any evidence that your invention was already known, including patents, publications, public demonstrations, or sales, existing before the competitor's filing date. Invalidation/defense. If you possess prior art that shows a competitor's patent is not novel or was obvious, you can use this in court or in opposition proceedings to invalidate their patent. Claiming compensation. If a competitor is selling a product based on your prior art, and you have previously disclosed this art, you may be able to demand licensing fees or damages for unauthorized use of what is now considered public domain or your own intellectual property. Steps to claim compensation using prior art. Document everything. Gather incontrovertible evidence of the prior art, such as dated records, technical drawings, prototypes, or publications. Analyze the patent claim. Perform a claim chart analysis, mapping each element of the competitor's patent claim against your prior art to prove that your work anticipates, fully discloses, their invention. Identify killer prior art. The most effective evidence is a single document or product that describes all features of a claim, rendering it invalid for lack of novelty. Legal action, invalidation/negotiation. Oppositions. In jurisdictions like the EPO, file an opposition to revoke the patent. Negotiation. Approach the patent holder with the prior art to negotiate a royalty-free license or compensation, highlighting that their patent is vulnerable. Key concepts in using prior art. Shades of gray. In prior art, products that are not fully disclosed, but are nonetheless discoverable, for example, through modern analytical tools, can still constitute prior art. Enablement. For prior art to be valid, it must be enabling. It must teach someone skilled in the field how to actually make and use the invention. Prior user rights. If you were using a technology secretly before a patent was filed, you may be able to claim prior user rights to continue using it, protecting you from infringement claims. Risks and considerations. Invalidity disputes. If a buyer or competitor claims your patent is invalidated by prior art, you must investigate their source and evaluate whether the prior art actually covers all elements of your patent. Expert consultation. Using prior art requires legal expertise to interpret claims and the technical knowledge of a person skilled in the art.